Let's start with a sharp procedural footnote from the 2021 family law case, TK v. ML. The presiding judge was, in his own words, weary. He was dealing with a seemingly ineradicable belief among legal professionals. The error? The persistent idea that if a family dispute is highly complex, it must physically commence in, or be transferred to, the High Court itself. That belief betrays a complete misunderstanding of how family justice currently operates in England and Wales. It treats the legal system as a collection of separate physical jurisdictions that you must travel between based on the severity of your case. To navigate modern family practice, you have to abandon the idea of navigating physical courthouses. Instead, you need to understand the invisible administrative engine that replaced them. That engine is the single family court. It is a unified national entity that collapsed decades of distinct geographical court borders into one single point of entry. Today, a lawyer does not file a case directly to a specific judge or route it to a specific building based on the matter's prestige. Every incoming application goes directly into a central triage mechanism. This initial routing process is known as gatekeeping and allocation. The gatekeeping team evaluates the initial filing to determine exactly how complex the dispute is. Based on that assessment, they assign the case to a judge of the appropriate rank and issue the standard directions that will structure the entire life cycle of those proceedings. The efficiency of the entire English family law system relies on this administrative funnel, completely independent of the physical location where the trial might eventually take place. While the single-family court presents a flat, unified entry point to the public, internally it maintains a rigid, highly stratified hierarchy. Under the Crime in Courts Act 2013, the court operates with a specific roster of judges. This ranges from lay magistrates at the base, up through district judges, circuit judges, and ultimately high court judges at the top. They all operate under the exact same umbrella. This means the single-family court handles everything from a straightforward financial consent order to an incredibly complex public care proceeding involving expert medical evidence. The exact nature and severity of the application dictates which tier of this hierarchy the case is assigned to. When a case escalates in complexity, the court itself doesn't change. You don't tack up and move to a new jurisdiction. Only the rank of the judge sitting within the single-family court changes. The gatekeeping team doesn't make these assignment decisions arbitrarily. They follow a strict statutory matrix found in Schedule 1 of the Family Court Rules 2014. This schedule contains an allocation table that functions like a sorting algorithm. It takes the legal nature of the incoming application, analyzes the data, and routes it down a specific track toward the designated tier of judge. For example, if a practitioner issues a financial provision proceeding under the Matrimonial Causes Act 1973, the table automatically defaults that case to a judge of district judge level. This allocation system is tightly integrated with procedural deadlines. In public law child cases, for instance, the gatekeeping team must determine the case complexity and allocate the appropriate judge by day 2 of the strict 26-week public law outline. If a practitioner suspects the gatekeeping team has made an error and assigned a case to the wrong tier, there is a correction mechanism. They can formally request a reallocation hearing under Rule 29.19 to argue for a different level of judge. This algorithm completely eliminates the old practice of jurisdictional shopping, but it demands absolute precision from the practitioner to ensure a case isn't misrouted from day 1. Having a single centralized structure has also allowed for rapid digital modernization across the family justice system. Practitioners can now use the HMTCS online portal to issue certain applications digitally, bypassing the need to file paper documents at local courthouses. The unified rules of the single-family court also facilitated a massive shift toward remote and hybrid hearings. National guidance explicitly lists several categories of hearings as highly suitable for remote attendance, specifically including routine case management and interim hearings. The architecture of the single-family court makes justice increasingly platform-agnostic, shifting the focus away from physical presence and toward procedural efficiency. However, the internal stratification of the single-family court creates one notorious procedural anomaly: the appeals process. Because judges of all ranks sit within the exact same court, you cannot simply appeal a decision by sending it to a higher court. Instead, the destination of an appeal is dictated entirely by the rank of the judge who made the initial order. If you want to appeal a decision made by a district judge, the appeal is heard by a circuit judge sitting right there in the single-family court. The case moves vertically, but it stays within the same institutional boundary. There are strict exceptions. For instance, an appeal against a care or supervision order made by a circuit judge must actually break out of the single-family court entirely and go to the Court of Appeal. The unified facade of the system disguises a highly complex internal maze. Practitioners who fail to understand the specific ranks of the judiciary can easily find themselves trapped in procedural errors. And while the gatekeeping algorithm is highly efficient in theory, the practical reality is a system under severe strain. The courts are currently facing immense backlogs. The calendar burden is so heavy that courts frequently list hearings as at risk. This designation means there's a very high likelihood the hearing will be vacated or postponed due to lack of available judicial time. This strain has a direct impact on families. It is increasingly common for complex matters, like financial final hearings, to be delayed for months, leaving the parties trapped in legal limbo. The single-family court is a powerful administrative funnel that successfully erased outdated geographical borders, but in doing so, it introduced a new regime of rigid, tiered procedures. True mastery of family law today requires seeing past the physical courthouse. It requires understanding and properly navigating the statutory rules of